Dynar is a litigation counsel with our new friends. We actually have been talking to them for a couple of years, but they do what the ACLU used to do, the New Civil Liberties Alliance. And Adi, I'm looking at this story. When I saw this story, I think Ben Shapiro had it about the NLRB and this simply the Daily Wire criticize somebody and they're in trouble. I mean, or am I simplifying this too much?
Hi, Fred. Thanks for having me. No, you're absolutely right. You aren't simplifying. The Daily Wire, which is a media publication company that publishes on current controversial topics, picked one of the controversial topics, which is, at the time, was the employees of Spotify that wanted to obtain some editorial control over Spotify's editorial decisions, and the Daily Wire criticized that employee action, and they were penalized for it.
By the NLRB, right?
Exactly. I mean, there's no reason to make a case out of it.
So the NLRB can now have. This is similar to the CDC getting into the rental business. It's like our federal agencies don't know what they're doing anymore, do they? Or maybe they do, right?
Fred, you're right. There is a difference between, honest discussion and debate happening over social media platforms and making a federal case out of it. Those two are totally different things. Now, we can understand if the National Labor Relations Board tries to investigate and prosecute an employer who is taking adverse actions against their employees. But this is a very different situation. We are just talking of honest discussion and debate on social media platforms.
So this is basically,
which is not within the.
So this is basically, I mean, if you want to simplify it some more, if you're not familiar with the Daily Wire, this would be like any of our major news out. It could be a newspaper, it could be a network, one of the major TV networks, criticizing these people, and the NLRB coming in to punish them. I mean, you would think, wait a minute, First Amendment, but it didn't happen in this case. Why?
I think the National Labor Relations Board has taken several steps in the past 1 or 2 years to regulate social media platforms anytime someone speaks about something that can remotely be perceived as touching labor relations. So, for example, in the Daily Wire situation, because it was a criticism of Spotify employees, the NLRB thought it had jurisdiction. The same thing we see with the Federalist Media case when Mr. Ben Domenech had published something on Twitter. The NLRB is pursuing that action as well. We also see that with Elon Musk's Tesla-related tweets, because all of these comments on social media are perceived by the National Labor Relations Board as touching labor relations. They think they have jurisdiction.
So we're going to have basically, as this kind of finds its way through the courts, because I guess this isn't going to be over for a while, we're going to have a First Amendment case, because this is basically First Amendment stuff, right?
Yes. And in addition to the First Amendment, I mean, First Amendment is definitely, one of the theories in the background. But I think the more important point is we aren't talking of employers going against their own employees. We have a situation where a random observer on Twitter saw these tweets and decided to complain to the National Labor Relations Board. So we can't have random people deputizing the government against people that they disagree with. That is wrong.
So tell me where this is right now. What should people be paying attention to?
So people should be paying attention to who is the complaining party. Typically, we see that in National Labor Relations Board cases, it is the employees complaining against the employer. So let's say, I have a union and my union is trying to bargain for better salaries with my employer, and I'm dissatisfied with that whole process. I can go to the National Labor Relations Board and get them involved in that labor dispute. So people should be paying attention to that. If you have a random observer on the internet using the NLRB against you, then that is a huge problem. The NLRB just doesn't have that sort of bootstrapping jurisdiction.
So this would be similar to, I'm trying to think of some parallels. This would be some federal judge somewhere just deciding without any case being brought to them that they were going to do so-and-so. And because there has to be some kind of filing, right? And in this case, the NLRB is just saying, well, we've decided that these guys were spoken unfairly about, and we're going to get involved. That doesn't work in any other jurisdiction I can think of. And again, it only seems to happen with federal agencies. This is frightening when you think about it.
That is right, Fred. And the important point here is that Congress has only allowed aggrieved parties, as you were saying, the case or controversy requirement. It's only people who have genuine controversies and who are genuinely harmed by some action that the employer has taken can go to the NLRB with complaints. But here we just have a random observer, and that is the crucial difference.
So how is this being resolved in the courts?
So with the Daily Wire case, I have happy news to share because the National Labor Relations Board dropped the case against the Daily Wire because of these arguments. But I have sad news with respect to the Federalist Media case because that case is currently pending in the Third Circuit Court of Appeals, which is the federal appellate court in Philadelphia.
So tell us about that case, because the Federalist one is similar, right? Tell us a little bit about how that one is even still in the court.
Happy to, Fred. So back in June of 2019, Mr. Ben Shapiro, who is the publisher of Federalist Media LLC, which is an online magazine dealing with, again, current controversial topics of interest, posted a joke on Twitter saying that whoever tries to unionize, he'll send them to the salt mines. And a random person filed a charge with the National Labor Relations Board. The National Labor Relations Board investigated and prosecuted Mr. Dominich's company for an alleged unfair labor practice because he joked about some labor relation issue, according to the NLRB. And we are fighting that case, and that case is currently pending on appellate review.
So this one, we don't even know if it's an employee. It was just a random person, right? So they may, an aggrieved party has to work for you. Or in this case, did they work for them?
Not at all. It's a totally random person. It would be the same as, some person living in Brazil sees something on the internet and complains to the NLRB in Hawaii because the employer is in Massachusetts. It's a very odd situation.
Does this end up? Does this end up being considered by the Supreme Court, or what are your prospects at the appeal level, and how has it gotten all the way to the appeal level?
So we went through a trial in front of the administrative law judge of the National Labor Relations Board, and those judges do not have to follow federal court cases. We lost in front of the administrative law judge, as was expected. We then appealed to the full National Labor Relations Board, which at the time was composed of 3 presidential appointed members. It has 5 seats, but the 2 seats were vacant at the time. The National Labor Relations Board affirmed the ALJ's decision, and that's how we ended up with the federal appellate court.
So this is really the first jurisdiction outside actually in the judicial branch, because, again, the NLRB, just like all these other federal agencies, claims to be judicial, legislative, and executive, right? Which, again, I'm wondering is going to be tested as constitutional at some point, I would think, don't you?
That's exactly right. This is the first independent Article 3 court that is going to review this case.
Wow. So what are your prospects? You feel like, so this could go a number of ways, right? Either the appeals court says, either affirms the NLRB, and this, of course, would likely be heard by the Supreme Court. I hope they would hear this one, or they reverse it, and then it still gets appealed to the Supreme Court, and they can either choose or not choose to take it. But this is, I mean, this to me sounds landmark, because if this is allowed, then what's to keep some myriad of other federal agencies from just following the same playbook, right?
That's right. And that's why, as you say, this is a landmark ruling one way or the other, because when Congress limits the agency's authority, we expect the federal agencies to stick by it. We don't expect the federal agencies to go on these sort of fishing expeditions and cost employers thousands of dollars to defend an action that should not have been brought to begin with.
Well, I can understand the NLRB probably siding with itself. That's not a shock. As a member of the judiciary, I had no idea. Well, I did. It's just I'm being funny here. But if this, my guess is the appeals court's probably going to reverse this. But I'm not a lawyer, and I'm not trying to play one. You are, and you are one. But is that your sense? That, I mean, as far as congressional intent, there's no doubt here, is there?
No, there is no doubt, and we hope you're right in this. But again, when we talk of lawyers and judges, there are lawyers on the other side as well. So we expect the National Labor Relations Board to muddy the waters a little bit. But I think I'm ultimately hopeful that an independent federal judge looks at this and tells the National Labor Relations Board to stop its shenanigans.
This is, you guys have been fighting this on a number of fronts, because I know I've talked to one of your colleagues about what the CDC's been doing in the rental business, and that's been kind of going, that case has been bubbling along too, and you guys have had some victories there. But we've got other activist agencies out there. I mean, you got the IRS, you got the EPA. I mean, you could go down the list. They get the idea that they can be judge, jury, and executioner. This is just going to continue, right?
Well, if it's up to the New Civil Liberties Alliance, we want to stop these practices, and I think one of the important limits, or the limiting principle here, is one of constitutional dimension. The Constitution requires some limits on agency authority. And one of the limits is when Congress gives the agency authority to do something, they have to stay within those tracks. They can't depart from it. And in NLRBs is just one of many situations. But as you said, CDC, EPA, there are just all of these alphabet soup agencies that have frequently tried to step beyond the authority that Congress has given them. And that is a system-wide issue, I would say.
I wake up every morning, I thank FDR for all those alphabet agencies, and you haven't mentioned them all. All right, so when is your case is expected to be? Is this going to be this? There may be arguments, there may not. Usually at the appeals process, it's a going through the case law, right?
Right. So we are waiting for some filings to be done in the Third Circuit, which is the Federal Appeals Court in Philadelphia. That should be done by the end of July, if not August. And then we expect to present orally to the court a few months after that, and a decision follows perhaps in early 2022.
All right, if people want to follow what you guys are doing, look, there's some great stuff, and you guys have, you do all kinds of cool stuff. I get your newsletter, which is awesome because it summarizes all the cases you guys are working on. Adi Dynar, Litigation Counsel with New Civil Liberties Alliance. Where do they find you guys? And if they want the newsletter, how do they do that?
So the New Civil Liberties Alliance, we have a website, nclalegal.org. And if you go on that website, again, it's nclalegal.org, you can fill out the contact form and we can send you the newsletter, and you can keep yourself apprised of all of the fun stuff or the not so fun stuff happening at the federal level.
Sane solutions for an insane world. Fred Holland.